Okay, well, thank you very much for your submission and the report and so on. Maybe you could just identify yourself for the record, your name, organisation and interest, and then we'll ask you about the submission.
My name's Lucinda O'Brien. I'm a policy officer at the Federation of Community Legal Centres, and I've been working with the Taxi Driver Legal Clinic.
Denis Nelthorpe, manager of Footscray and Wyndham Legal Centres, and we've been operating a taxi driver, I should say taxi owner and driver legal clinic for about 18 months.
And we have read your submission and quite big report, but maybe you could briefly give us a summary and other things you wanted to bring up.
I might go first. Thank you very much for giving us the opportunity to come and speak with you. Essentially, we wanted to emphasise our support for the inquiry's draft proposals regarding changes to the bailment agreement. As you will have seen, that's a major concern of ours, that the current bailment agreement does absolutely nothing to protect low-income bailee drivers who are vulnerable to all kinds of pressures, who have no minimum conditions or no minimum wages, and of course an issue of particular concern to us, have no protection against financial ruin in the event of a car accident. That's what initially led us to set up our clinic, and we've seen terrible instances of people being exposed to debts of $20,000, even more, often when they have been paying money for what they believe is insurance, and as a result risking bankruptcy, risking loss of their homes if they have one. And we see this as an issue that's crying out to be rectified. It's fundamentally unjust that people who have so little power and so little stake in the industry should be exposed to this risk, often when they have no idea that they're running this risk and no capacity to protect themselves. So to conclude briefly, we strongly support the inquiry's recommendation that insurance be made compulsory. Of course, as you know, this is already the case in several other states in Australia, and we think it's absolutely unquestionable that it needs to happen here in Victoria as well.
And perhaps if I can just expand on that a little and comment on one of the inquiry recommendations. We've been working very closely with the Insurance Council of Australia, who have put in a submission supporting what we've been saying. We've also been working very closely with individual insurers. However, the bottom line is that if insurance doesn't work, and I mean insurance in inverted commas because it's not insurance, it's not governed by ASIC, the Corporations Act, or the Insurance Contracts Act, but if it doesn't work, the bottom line is the drivers or owner drivers are liable. Any accident out there in the street, even if you have insurance, it doesn't mean you're not liable, it just means you have insurance to cover it. Now, when you consider that drivers are on the road 12 hours a day for 5 or 6 days a week potentially, they are obviously at far greater risk. And the amount of money, we're currently representing a 57-year-old man who has been in the industry a couple of years. He was leasing a licence and a cab. He had a driver. He thought he had insurance. He paid the premiums. He's being sued by a mainstream insurer for $46,000, which is far in excess of the equity in his home. The cab's a write-off. He has absolutely no ability to pay it. And basically, even if the insurer does the right thing, and at the moment that insurer is saying, well, they're interested in finding a way to pursue the taxi club, and there are 2 or 3 taxi clubs that are well known for simply taking the premiums and never paying. But at the end of all of that, this man may lose his home. We've also had drivers who were faced with bankruptcy. Now, one of the issues that I wanted to comment on was that in New South Wales, as I understand it, an owner cannot ask a driver for a contribution to the excess under their scheme. The report recommended that an excess be allowed. Excesses are between $1,500 and $2,000 if they're legitimate, But if the taxi club wants to discourage a claim, it can simply make the excess $5,000. They rarely get documents that they either don't get the documents at all or they can't read them. So my view is, firstly, if it's a driver, they shouldn't have to pay an excess at all. But even if it was an excess of $350 to $500, which is what you would get under a normal insurance policy, that may well represent at the current rates of pay, that would well be equivalent to a full week's pay. If you're allowed to, and I'm sure the industry would love to do it, force an excess of $1,500 to $2,000, you're actually talking about a month's salary. And I don't see how you can legitimately ask drivers to drive unless you say to them up front, one accident and you'll have to drive for a month for us. Now, and that's just not viable. If we're going to have drivers, they have to be driving under reasonable circumstances. The second concern I have, we strongly support the recommendations in the draft in relation to changing the payment arrangements for or the returns on the licences. There's no doubt we've looked at a number of owner drivers who have started out to build up a fleet, had 3 or 4 cabs, only to find that by the time they paid the fees on the licence, the fees to the various for the various facilities, that actually they weren't making any money, they were making losses, and in one instance 2 of the cabs were subsequently sold for $1,000 each. So I have a concern that if there was an introduction of compulsory third-party insurance, unless the economics of the industry change, the owner drivers won't be able to afford to pay the premiums. So there has to be that fundamental change in the way in which the returns to the industry are distributed.
So a fall in the assignment price, for example.
Yes, absolutely. There's also concerns for us that we probably didn't highlight as much in the report. There is absolutely no one that the taxi Directorate does not appear to have a statutory role to be concerned with the welfare of the drivers, even at the level of what sort of agreements are being signed. So it's not uncommon for us to see very unsophisticated drivers signing handwritten drafted contracts where they start to take on the risk and agree to pay, $800 a week in advance for the right to drive as a driver. There's no question about, well, what's legal or illegal? Can anyone tell them whether that's a legitimate contract? We've written to a few people saying we find it hard to believe that's enforceable. If you want to sue, we're happy to defend. But drivers need protection from some of the agreements and some of the practices in the industry. And hopefully the creation of a taxi commission might put more emphasis, and this is where I think drivers need to be more like normal employees. And just to go back to Lucy's point on the bailment, we've made inquiries, for instance, from JobWatch, which is a specialist legal centre looking at, nefarious work practices. And we have could find no other evidence of bailment in any other industry in Victoria. We've asked around interstate. This appears to be the only form of bailment. Now, I have heard that some hairdressers, for instance, will lease out under bailment the hairdryer thing in the salon. But that's an arrangement where you go in, you use it and you go out. And even that appears to be incredibly rare. So as far as we can ascertain, this is the only example of bailment left in this country. And I know everybody says, oh, well, reform will take time and the industry's got to be able to cope with the change. But, this is a bit like the equivalent of sending miners down into the coal mine with a canary. There has to be some question about how long a Dickensian form of employment or serfdom should be allowed to continue, because it clearly leaves these very unsophisticated drivers, and I should add, and we point out in the report, We've had drivers who can't get Centrelink because they don't have residency. We are talking about, and we're forcing the most disadvantaged people into these arrangements. So I guess, sum up, the sooner we understand that the change from bailment to a driver agreement and moving away from bailment may have to be staggered, we can accept that. But we would like it accepted by the industry that this is a Dickensian form of employment that isn't mirrored. I think it is mirrored overseas in some of the other taxi industries, but as far as we can see, it's not mirrored anywhere else in any form of employment in this country.
What do you think the impact of your changes would be on the nature of the kind of supply of labour? Do you think you'd get a very different labour force or similar people but better looked after?
It's noticeable that even the most disadvantaged and unsophisticated drivers, once they realise they're being ripped off every which way, will abandon ship pretty quickly. I think if the industry wants to employ reasonable quality drivers, people who have been in the country a long time, who know the roads and so on, then they have to offer reasonable conditions. And nobody with any sense would drive under the current conditions. For instance, with the insurance arrangements as they are, I've been tempted to get on some of the radio programs and say, if you own a home or you're buying a home and you're driving a taxi right now and hearing this, the smart thing to do is pull over the side of the road, lock the car, give the keys to anyone who wants them and walk away. So if you want reasonable drivers, you're going to have to they've got to be treated like human beings. I don't know anybody who would drive if they truly understood the risks and had any alternative.
So on the issue of employment and bailment and so on, I suppose it's been put to us by a number of people that we shouldn't go down the route of trying to recommend mandating employment because actually there are drivers that like the arrangements of operating on a share of the meter and the notion of being a sort of their own businessman, business person or whatever. What do you say to that situation?
I'd say that over the history we've had many people who were being exploited and perhaps didn't know it, many people who were working in exploitative conditions and tolerated it. You cannot get away from the fact that the current bailment arrangement, you've only got to look at the model agreement that's on the website that says you're entitled to be indemnified by the owner, but not for negligence. And the question isn't whether people like the idea of being, self-employed or having a sort of profit role. The question is, are they earning a reasonable rate of return for their time and are they being exploited? The real question in our view comes down to that. Are they being exploited? And the answer is, hell yeah.
And can I add as well, we understand that, of course, some people will want to have a more entrepreneurial kind of engagement in the industry, and to that end we really strongly support any measures to make it easier for people to lease their own licences from the government and then truly be self-employed rather than working for someone who's leasing a licence and then kind of subcontracting half of the shifts to someone else. I mean, truly running your own business in the industry would, to my mind, involve having your own licence, and I think that's a really important goal.
And do you have any particular views on the alternatives that we put forward, whether you accept there's a sort of transition towards perhaps more reasonable remuneration and so on? So one option was the 60-40 option that we recommended, as opposed to sort of setting a minimum wage, which was less than, if you like, the minimum in the award, certainly. But did you have any view on that?
Look, I don't personally have a strong view. I don't know what would be preferable to the participants in the industry and what would serve them better. But certainly something has to be done to guarantee them something equivalent to a minimum wage, whether that's calculated on an hourly basis or as a proportion of average metre takings. There has to be something done to ensure that there's a sort of non-negotiable minimum that they can expect to earn for putting in 12 hours behind the wheel. But I don't know which way would be the more effective and more viable.
Just wondering, one of the issues about, some of these people have the freedom, to work in a particular way. It is worth noting that as I understand it, under original bailment, the bailee, I've got that wrong, right, would have certain rights, for instance, to refuse certain fares, to refuse certain routes, would actually have some real control. When you look at the combination of the bailment agreement as written on the model agreement and the legislation and rules of the Victorian Taxi Directorate, our bailee drivers have none of those rights. So they're not, they don't even have the rights of the sort of horse and buggy driver back in the Dickensian age. If they had some rights, if they had the right to refuse short fares or say, no, I don't want that route, I don't want that time, it might be different. But what we're trying to say here is, no, we're going to tell you when you drive, how you drive, what you'll wear, and then pretend that you've somehow got some sort of status as self-employed. I mean, it is a nonsense.
So there's there's a combination of regulation as well as the employment relationship there that's a bit mixed up. But it's leading
threefold.
into...
The regulation takes away a huge number of their rights. The employment agreement gives them no rights, and the economic return forces them into a virtually economic slavery.
Well, and as I think we may have indicated in our first submission, we have a barrister's advice saying that the status of the bailment agreement, its consistency with Victorian common law is dubious, in that several Supreme Court decisions have held that drivers are not just bailees, they are agents and therefore have far more rights than are reflected in the bailment agreement that the Victorian government currently seems to promulgate, although I note that it doesn't take full responsibility for the contents of the agreement. That's something we think needs to change as well. Is we need, as Denis has already indicated, we think the government needs to spell out much more clearly its responsibilities to these drivers. When you look at the WorkSafe documents about occupational health and safety in the industry, for example, they say contact the Victorian Taxi Directorate if you'd like more information or if you need this information in translation. But when you contact the Victorian Taxi Directorate, no one has the faintest idea what you're talking about, and actually several people have told me we take no responsibility for occupational health and safety of drivers because they're all self-employed. So there seems to be a real lack of understanding or lack of certainty even within government as to what the government's responsibilities are to these people, and that really needs to be clarified quite urgently, I think.
With the reform, say 60-40 or the alternative, one issue is whether they might be evaded in various ways. There are different imaginable ways in which that might be done, by direct non-compliance or by offsetting that with some other thing. Like maybe you make the drivers pay for the petrol or whatever, or LPG or whatever. Have you any views on that? That was my first question. I have another one after that.
Well, we know that the 50-50 was not only reduced to sort of 48-52, but drivers were saying they were being forced to pay for petrol and various other things. So would some... but I also think part of that comes from owners. Perhaps go back a step. When we started with the legal service, we thought we were talking about representing drivers and that owners were the other side. It fairly quickly became apparent that most of the owners were almost no different from the drivers. Many of them were lucky if they even owned the cab. The cab, they had it on finance or they leased it. They often had negative equity in the cab itself. So unless the owners, and I don't mean the owners of the licences, I mean the owner of the actual cab, are achieving a reasonable rate of return, then yes, they will almost certainly try to find a way to reduce the return to the drivers to try and make themselves more viable. And to give you an example of how that works out, we've got clients who have no assets but have been allowed to borrow 60 to 90,000 to purchase a new cab and to lease a licence. Now, I mean, it's a pretty sad comment on the industry that anybody would allow you, and it came from a specific financier within the cab industry. But, you know, you shouldn't be allowed to borrow 60 or 90,000 if you don't have any assets and any ability, anything to stand behind you.
And if I could just add, Dennis, do you mind? Of course, there are always going to be people who try to get around any kind of safeguards or regulations you put in place to improve the working conditions of drivers, and that's why we think that the Taxi Services Commission needs to be adequately resourced to make sure that the new regime is upheld appropriately. I mean, to be fair to the Taxi Directorate, I'm sure they don't have anywhere near the resources they need to ensure compliance with the standards that are in place now. And my conversations with New South Wales government bureaucrats have led me to think that there's a real ongoing problem there in terms of ensuring that the comprehensive compulsory insurance requirements are met and that drivers, owners do make sure that there's an adequate policy in place and that the documents are always in the glove box as they're supposed to be. I mean, it's inevitably going to be a hard industry to regulate, I guess, because it's so geographically dispersed, it's constantly mobile. That's just a challenge that I don't know how you get around that, but certainly the Commission is going to need to be adequately resourced to make sure that people can't just flout the new rules with the ease with which they seem to flout the current ones.
Do you see your federation playing any role in taking any steps that would be assisting in regard to breaches of the law in that regard? Like, would you make representations or receive complaints or anything?
Perhaps we established the Taxi Legal Service with a grant from the Legal Services Board for 12 months. Now, because the inquiry was set up and we want to see it through, a couple of us have essentially put our time in, but the insurance and debt problems created are fairly significant. We've also assisted with accreditation issues. We'd probably be willing to continue, particularly given the drivers at the moment don't earn enough to belong to a union even if they wanted to. We'd be willing to provide some ongoing assistance, but I guess we'd be looking to, I don't know, the Commission, the Taxi Commission or someone like that to provide some resourcing. It's not hugely work intensive, but things like, it's a very specialist area, and asking your average first year lawyer who joins up at a legal centre to get their head around a taxi industry is a bit tough, really. But in theory, yes, we'd continue to provide some support, because I think we'd have to say that this is one of the most disadvantaged group of workers you could ever find.
In your 18 months doing this, roughly how many clients would you have seen from the industry? I mean, just to get a bit of an idea of the level of... Just an order of magnitude.
I think we saw about 180 in the first 12 months. Or we had 180 matters. A few of those matters were same client, different issue. That's in the 12 months that we were funded. I'm afraid I don't have
we continue. What we've done is we've tended to say if it's fines because you're a bad driver, we can't do anything more than anyone else on that. So we're trying to limit ourselves to the civil insurance and sort of contractual disputes or accreditation. We're still seeing, we limit it to about 4 appointments a fortnight. If we could continue to run it weekly, we'd probably double that, I would imagine. We are still seeking, as I say, 2 weeks ago, the fellow who is at threat of losing his home for a $46,000 debt came in. One thing we are seeing is that because we've become better known around the place, some of the intractable disputes or problems that have been out there for 12 months are being gradually directed our way, which is good and bad. But I would say that on civil disputes alone, we would easily, if we had the resources, to be able to see 4 to 6 people a week, I reckon.
And I mean, we've been conscious that there are probably a lot of people out there who could use legal assistance who never hear of us, but especially since our funding has ended, we've been a bit reluctant to go on an enormous publicity drive because we just wouldn't have the resources to help.
And I should also say there are areas like Frankston which operate under different, as I understand it, in a different region. We've just had one case referred up from Frankston where we hadn't heard of the taxi club. We don't know the sort of players, and if we went down there and advertised, no doubt we'd pick up another 20 clients. So we've really tried to take enough clients to get an understanding of the industry and the problems without being overrun, basically.
You've got a number of recommendations here in the paper. Do you want to talk to those at all? So the first one was that the TSC should implement strategies to raise drivers' awareness of Victoria's Victims of Crime Compensation Scheme. What's that about?
Well, we've come across a number of clients, a number of taxi drivers who have been the victim of a crime. They've been assaulted, for example, while they were driving the cab, and to our knowledge, nobody's drawn their attention to the existence of this scheme or to their potential eligibility under the scheme. There is a link to the tribunal on the Taxi Directorate website, but you have to look pretty hard to find it. And if you go to the main page on the Victorian Taxi Directorate website that says driver rights and responsibilities, the responsibilities are at least 10 or 12 in number, but the rights are only 2, and I'm not even sure what they are, but they certainly don't include any information about work cover or eligibility for victims of crime compensation. So we think there's an enormous lack of awareness in the industry as to these schemes and drivers' potential eligibility under them.
We also had a client, I thought, that highlighted this issue where he had had discussions with his father in India about whether it would be the right or wrong thing to A, cooperate with the police in trying to identify the person who assaulted him, and B, make an application under the Victims of Crimes because that might be seen as creating trouble. I don't think the general community has any idea how marginalised and disadvantaged some of these people are. We also had one client whose family was still living in India, who clearly felt that if he took any action to protect himself, he may disadvantage his ability to bring his family out here. So they often have real problems in that way. The second recommendation was we think that the new commission, as we've said, should have an explicit requirement to look at least some aspects of driver welfare, so that, for instance, in particular, the nature of the agreements they're entering into. Alan, you were mentioning earlier about getting around some of these agreements. If an owner or a licence holder creates some unusual form of agreement and requires a driver to sign it, I think the Commission should be required to at least ensure that it's not a grossly exploitative sort of document.
With the indemnity for damage to third-party vehicles, are you suggesting that no excess should apply? Is it
only to the drivers? The owner-driver or the owner clearly should pay an excess, but the drivers themselves, they should be employees. It's up to the owner to decide whether they're suitable to drive. I can't see why, a driver should be required to pay for an excess on someone else's vehicle as part of their employment.
And as far as there being a disincentive to have, an incentive for drivers to drive carefully, I mean, I imagine that there's always going to be the incentive that if they have an accident, they'll be off the road, they'll lose in the short term their income, and in the long term, if they persist in having accidents, they'll lose their jobs in the same way that anyone would lose their jobs if they persisted in having expensive accidents at work. I mean, it's not as though by removing the requirement for drivers to pay excess, you would give them free rein to just go crashing into everything on the road. I mean, it's sort of common sense, I guess, but certainly if there is to be an excess payable, we think it should be very strictly capped, because, as we've already said, the current excesses that are being charged are grossly disproportionate to the average earnings of drivers. So.
Recommendation 6 was one of my favourites, because I must say I was pretty amused at and I don't want to be unkind to the taxi directorate, but they were sending drivers who often couldn't read English, some who could barely speak it, a correspondence that was befuddling to the volunteer lawyers we had. Even things like putting the date on the letter at the end of 4 or 5 pages, not on the start, which made you think that you'd got an undated letter. But the quality of correspondence they couldn't possibly have understood what was being said. And I think we need to make sure that however you run the system, the communications directed to the drivers could possibly be put in a language that gave them an outside chance of understanding. It would be a really good start.
Yeah, and when you consider that it's their livelihood that's at stake, I think it's something that needs to be taken seriously. If they don't have any meaningful opportunity to put their case or respond, then you might as well not have a process of review at all.
I think we've covered the others.
Yeah, I just want to mention that on the funding for the Legal Centre, we actually think this is only a day or two a week. We're happy to use volunteers. We found we can do the accreditation with volunteers, but some of the civil disputes are pretty complex, and we're happy to sort of, do what we can. But in a sense, where Footscray is at the moment, essentially taking funding for people in the western suburbs and directing it to try and assist drivers. I'm not sure that's an entirely satisfactory arrangement.
And can I just quickly say something?
Yeah.
And just quickly, in relation to recommendation 6, we do think that, if possible, the inquiry could give a little bit more consideration to the fact that many drivers are from non-English speaking backgrounds, and while...
Can you put that the other way? There are almost no drivers from an English speaking background.
Yeah, perhaps that's a better way of putting it. And so, particularly with written English, we think there are some real problems with expecting these drivers to read very complex correspondence, but also the Taxi Directorate doesn't seem to take seriously the needs to provide information to drivers in their own languages. I mean, when I've asked them, the WorkSafe document again says at the bottom, if you need this information in translation, contact the Taxi Directorate. And when you ring the Taxi Directorate, they say, no, these documents aren't available in translation, and why should they be? Because taxi drivers all have to pass an English language test to get accredited. I mean, that's just, of course, they need to speak basic English, but to suggest that all taxi drivers have to have, a very detailed command of written English in order to get accredited is absurd. But that seems to be the expectation or the assumption on the part of some people regulating the industry at the moment. So if there's something that can be done to make that information more accessible, that would be a good thing.
Thank you.
Perhaps they could be tested on their reading of this report from one end to the other.
I wouldn't wish that on anyone.
They might not then want to drive taxis anymore.
Okay. Is that it?
Yeah.
Thank you very, very much.
Thank you both very much.
We'll now take a break.